Thank you very much. So welcome along, everybody. Thanks very much for coming and listening to me. I really appreciate it. So just a quick show of hands to start with. Who, and you can just put it up like that. Who is a sole, I'm going to ask sole trader or limited company. Who's a sole trader? And who's a limited company? Okay, even split, so that's good. And the next question is, does anybody employ any staff here?
No. Mark Exley, do you employ staff? Yeah, he does, yeah.
Good. Well, that's, you know, the bit that I'm going to talk about, Mark probably knows, so does Sue. But there you go.
So they're my quality control, Stephen.
Is that what it is? They're the ones that are checking the work. I better skip over those bits then.
We might learn something. That's what I'm here for.
Yeah, unlikely. Right, so first things first, my name's Stephen May there, for those of you that don't know me. I am a solicitor. I've been a solicitor for the last 12 years. I like to call myself the right lawyer for you and your business. And the reason why I say that is because I've helped thousands of clients over the last 12 years in legal matters worth tens of millions of pounds. Over the last 12 years, I've been involved in more dispute work than anything else. But really, the thing that gives me kicks is helping business owners make the right decisions in their businesses, particularly in relation to legal risk, looking at their contracts, employment law, and dispute work. I like to say that I help business owners to sleep at night, or at least get a better night's sleep, because I take away their worries and sort it out for them. I've been, over the last 12 years, I've been reasonably well recommended by people. I've got some good reviews. I've been featured in local media, Leicester Mercury, Harbour Mail. I've been featured in the Times, the Sunday Times. I've been on local radio as well. So I hopefully know what I'm talking about. That's the point of that bit. So today's little speech is about getting your house in order. It's something that I'm quite passionate about, and I've seen a lot of clients already do this. And one of the things that I picked up on, if you've heard of the guy called Jim Rohn. Jim Rohn's my favourite author and presenter, business philosopher, passed away a few years ago, but over in the US, and says some really good things. And one of the things he talks about is the seasons. And he says that spring always follows winter. And we're in a bit of a winter period at the moment. And you have to take this opportunity to plan and grow and know that spring is coming. Spring being the season of opportunity. And so lots of clients, and I'm telling all of my clients, to take this opportunity to sit down and sort the stuff out that you didn't get around to doing over the last 6, 12 months, year, 2 years, 5 years, because you've been too busy doing the work. Now's the perfect opportunity to do it. And so the purpose of this chat today really is just to highlight a couple of things that people should in business should be thinking about, looking at right now when you've got the time to sit down and plan things. So the first thing that I recommend you look at is your contracts, your terms and conditions, and any other contract that you've got, right? So terms and conditions are really important. Hands up who has terms and conditions when they're dealing with customers. So that's a good start. So yeah, that's pretty much everybody. The people, oh, and there you go. Kalpesh got a thumbs up as well. I'm impressed with that. I was about to take the mic. So well done. So terms and conditions are really important, and they're really important to make sure that you don't just have some standard form ones that you stole from another website, that they are bespoke and they work to your business. And there's a few things that are really important when we're looking at terms and conditions. So firstly, if you're dealing with a business and it's a business-to-business transaction, then you can limit your liability. Now, you might not want to do that from a practical customer service point of view. You might want to, if you make a mistake, hands up, I've done something wrong, and here's how I'm going to remedy it. But from a legal position, you can have a limitation of liability, so that if you do something completely wrong, you do mess up, things happen, people make mistakes, that you're not then liable for lots of loss of profit, their ability not to trade, etc., etc. So those things are really important. You can also have in terms and conditions protections against what happens if something like COVID-19 happens and no one can do any work. So you could have terms and conditions that have what's called a force majeure clause in it that says, if something like this happens, then we're not able to carry on doing the contract, and this is the effect of that. I always think terms and conditions as well just looks more professional. So, you know, when you're quoting, you're sending out your quote and your terms and conditions, you look like a proper business rather than anything else. So that's another reason to do it. And finally, the other reason that I like terms and conditions is because you can put in place provisions about debt recovery, how invoices are paid, etc., when they become due, and interest, and you can claim interest on them, and you can do that without terms and conditions as well. But if it's set down in a contract and you go to court, the court will award you what's in your contract and not some other rate. If it's not in your contract, it's always been the case that that you'd be able to claim 8% on your interest, 8% interest at the county court. But over the last 4 or 5 years, no judge has given anywhere near 8%. It's more like 1% if you're lucky, unless it's written down in a contract, then you get more. So that's number one, terms and conditions. Number two, and I've seen a lot of this forward planning at the moment, is partnership and shareholders agreements. So partnership won't count here. No one's in a partnership, sole traders on partnerships. But if you're in business with somebody else and you're not a limited company, then you're a partnership. And if you are a limited company and you have another shareholder on board, it's not just you, then you should have a shareholders agreement. Even if that shareholder is your partner, your spouse, or best mate, then you should be looking at having a shareholders agreement. And what a shareholders agreement does is it just regularizes, it's a contract between the shareholders. And what it does is it sets down terms and conditions that govern that relationship. And I've seen lots of people have a business that they start up. It's with their mate usually, and they're good mates, and they've got this plan to grow, etc., etc. And they get to a point where either they want to sell the business, or they fall out, and there's a dispute about what happens to the business. And without a shareholders agreement, it becomes an incredibly messy process. If they can't resolve the differences between them, there'll be a court battle in which tens of thousands of pounds are sorted out, are spent to sort out, this company that's in existence. So getting a shareholders agreement is in place now. If you're planning for that future growth, is really important. Really important for things like exit planning. If you've got, you're the majority shareholder and you're giving shares to other people to incentivize them, then you can control those shares. So if somebody, leaves your employment, they have to hand back their shares and they don't get a windfall. If they're sacked, they're not going to get a windfall. And also, if you get to a point where you, as the majority shareholder, want to sell out of the business, you can force them to sell their shares as well at a set price, at a given price. Equally important, though, when you're dealing with husband and wife or other partners, life partners, because if you're in business together and you split up and divorce, the business is a separate entity. It's a separate thing. And so you might want to have a shareholders agreement that even sorts out the shares on a divorce, puts in place a mechanism for valuing those shares, or just allows one person to leave the company and go their separate way. But it's important that that's dealt with. I see a lot of accountants set up companies for people where it's just a 50-50 straight split with the husband and wife, whatever, and it's not really the best way of doing it. So some thought and planning needs to go into that too. So that's partnership and shareholders agreements. The next one is stuff that I think Mark and Sue will help you on as well, but basically is taking time to look at your employment contracts and your staff handbooks in particular. So what I always say about employment law is that people tend to say to me that it's a minefield. Employment law, it's a minefield. Who would want to employ people? And I say to them, it isn't. It is simply about following processes. And therefore, to follow processes, you need to have the processes in the first place. And the best place to have a process is in the staff handbook. So if you've got a staff handbook, pretty much whatever the problem is, that can be dealt with, it's disciplinary, they're not performing, they're not capable, they want a holiday, they want to go on maternity leave, they're adopting, whatever it might be, you have a policy for it, and then the employee knows what the rules are, the manager or you know what the rules are, and as long as you follow that, you'll be fine. Now, obviously, you can't rule out someone being a racist bigot and sacking someone because of some of their blatant prejudices. That's going to cause an employment tribunal. That will be a minefield, but you're a racist, so you probably deserve it. But if you're not, and you want to make sure that you're protected, then having it put in place in a handbook is really, really important. And I think that almost whatever size business you've got, if you've got just one employee, for the price of having a small handbook that sets down things like your disciplinary policy, capability, and what we call the family-friendly policies, maternity and paternity type leaves, it makes sense so that you know what to do, they know what to do, and you've got it all written down, so you're just following the rules. So that's that. Number 5 is sorting out a will and sorting out a business power of attorney. So wills are, people that draft wills at the moment are very busy because everyone is worried about dying for some reason. But important things to have in any business as part of your ongoing planning. So if you're a limited company and your business can run without you, which is a great business if it can, then a will determine who gets the shares of the business, who can then carry on running the business, what happens to any of the money that's inside the business, in terms of the bank accounts, etc., etc. So having a will linked to looking at the shareholders agreement and planning what happens on death is something that's really worthwhile doing and an important part of planning. You can also have situations where you don't quite die, but you are incapacitated. That could be mental capacity issues or physical capacity issues. And to protect against that risk, we have in place a business power of attorney. So a power of attorney is where you appoint somebody to make decisions on your behalf. Someone trusted, someone that you know is going to make decisions that you would want to make, but where you physically can't, make bank transfer payments or sign mandates, etc., etc., or you lose your mental capacity and someone needs to make the decision. Now they're very low cost things to do in the grand scheme of things. So, you're probably looking at £300 or £400 to get them done across the board, that kind of fee. But if you don't get it done and then you lose capacity, and somebody then has to stand in your shoes as a director, shareholder to manage the company, or even to wind the company up and pay off people and distribute assets, it requires either a liquidator to do that, which is a cost, or going to what's called the court of protection to appoint an attorney and to do that, which is probably a 9 or 12 month process and cost you a few £1,000s. So having in place a business power of attorney is something that's really important, and not many people do. Not many people realise that it's A, important, and B, it's the cost it is. So something that I thoroughly recommend. And the final thing that I see a lot of clients doing at these kind of times, recessions and the like, is taking the opportunity just to plan for growth. So I've got a couple of, I've been instructed on a couple of new matters over the last couple of weeks. You would think that most people are, pulling down the shutters and not doing anything. But these people that I'm looking at, they're either taking on external investment to help their company grow, or they are investing in other companies because they see that that's either a good company to be involved in, or a change in delivery of services. So one, for instance, is an online pharmacy, where their expectation, their hope is that at some point they get bought out by someone like Amazon. But they're putting in place a national infrastructure whereby rather than going to your local chemist, it just comes through the post, right? And so I've got a group of people that are investing quite a serious amount of money into that business so that it can take off and grow. And so what I'm seeing again is and I've seen in previous recessions, is it's not just about shutting up shop. It's about looking at the opportunities, taking that opportunity and going, yeah, do you know what? I can do this, I could do that, do that. Now, it might not be investing. It might be looking at your own business, of course. It might be going, right, what do I need to change in my way of working, my delivery methods, et cetera, et cetera. What can I do now to plan for that future growth? Because, as Jim Rohn said, spring always follows winter. So that's me, Stephen Mather. Any questions?
Right, let's see. Okay, has anybody got any questions for young Stephen? Either raise your hand or virtually, or put something in the comments.
Yes, please.
Cowpish, is that you?
Yep, it is.
Yep, go ahead.
Hi, Stephen. I'm sorry about the lack of the video.
Sorry?
Can you tell us a little bit more? Sorry. Can you tell me a little bit more about the force majeure clause you were talking about?
Yeah.
Particularly in relation to something like a franchise agreement, please.
Okay. So a force majeure clause is a clause that's in a contract that says if something, what we used to call an act of God, something major happens that's outside of anyone's control, then this is what would happen. So, you know, it might be that the contract can be terminated or it can be paused for a period of time, and no party is liable for performing its obligations under the contract. So in a franchise agreement, that's probably a bit more bespoke than me just answering it on a Zoom call now, Calpis. So if you want to just give me a call afterwards, we can have a chat through about it. But what you tend to see is in a franchise agreement for everyone else is you have a franchisor and a franchisee. One is the person that is providing the system in place, and one is the person that is doing the work under it. And I wouldn't expect there to be, and in particular, much of a force majeure clause in that, because it tends to be, because you're as a franchisor, you're a franchisee. Sorry, you're on your own body. I wouldn't expect there to be any kind of stop in the obligations on the other party in providing their services. But happy to have a chat with you about it, and if you've got any special circumstances, we can have a look at that. No problem.
Perfect. Thank you, Stephen. I appreciate that.
Okay.
Okay. Anybody else for Stephen? Stunned silence, Stephen.
That's all right.
Mark's got a question. Do you want to unmute yourself, Mark?
Yeah. Hi, Stephen. Just a question from me, because we're going on quite a lot of forums about employment law at the moment. By that I mean these kind of calls, but with some pretty eminent barristers, etc., who are dealing with nothing but employment law. The force majeure situation in terms of employment contracts seems to be a non-event, really. So a lot of employers are sort of saying, oh, well, we've got to just do this because it's a force majeure situation. In reality, they've got to agree these things with employees. So it's interesting because obviously normal contracts, I remember the act of God thing coming in before. I think I understand that, but I think there could be a bit of confusion there, that people feel that because we are in this extreme situation, then all bets are off and the contract doesn't apply. So we're trying to shoehorn agreement effectively into the minds of our clients to make sure they realise that as long as they agree it and get it signed up, they can do things, but they can't just do it anyway because, well, that's what you have to do.
Yeah, exactly. Yeah, so exactly that. You see a lot of, I've seen a lot of clients wanting advice on the same areas, which is, can we just furlough them? No, you need an agreement. Can we just sack them? No, can't do that without following a process. Can we just make them redundant? No, you need to follow a process. So yes, from an employment law situation, everything is still the same.